Hello.
Hi, good morning, Judge.
Good morning.
All right, we're back on Felipe Serna Reyes. I think I request that we go on the record on a few matters.
All right, have you conferred with the state on your motions?
I have.
All right, have him come down. Could I have parties announce?
Andrew Harrison within the state.
And this is Pauline Portillo along with Ms. Peyton Howe for Mr. Felipe Serna Reyes.
All right, you all are scheduled for jury trial today. You filed a motion for continuance?
I did, Your Honor.
All right, and why?
We have several reasons. We do have a motion to inspect and examine evidence, which if granted, I think will require us some time to inspect and examine that physical evidence.
Why wasn't that done before today?
Because, Your Honor, through preparation with my client, which was very limited because of the time frame which we represented him. This was information I had to develop over the course of jail visits, which I had to, I couldn't get within 24 hours. And so through prepping with my client, we learned of some evidence that might be, and I would expect strongly would be material and mitigating to the elements in the case. And so that's the reason why it wasn't filed earlier on in our representation of him. But it was filed before the jury trial date of
27.
the 27th, yes.
All right, anything else with regards to your motion?
I'm sorry, it was filed May 23rd, 2025, and I'll address that motion in a second. But the other issue is, Judge, we had requested missing discovery from the state, and since that request, we've gotten in about 12 videos that are pretty large, and even the state said it's a pretty big file that it took.
What missing discovery?
At this point, it's all been produced, but they are all recordings from SAPD personnel who are at the scene.
Okay.
And they're pretty large videos, Your Honor, and one of them I think includes the unmuted portion of the defendant's statements. And I also believe that that's going to have material and mitigating evidence for his defense. So it's really, really crucial for us to be able to review all.
All right, so review the video now.
Judge, these videos are an hour and a half.
Review the videos now.
Will do, Your Honor. And then the other issue with the motion for continuance is the other issue with the motion for continuance, Judge, is that to prepare an adequate defense for him and to avoid issues of this case being appealed for ineffective assistance of counsel.
People love to throw around ineffective assistance of counsel. This case has previously been set. He had another attorney. It was set for jury trial, and your firm decided that you were going to represent him and get on a case knowing that it was set for trial. So if you all want to throw your swords on ineffective assistance of counsel and file that with the appellate court, that's completely up to you. Next one.
Your Honor. The issue is that it is very apparent to me that because there was so much missing discovery that was never requested, that there was not adequate prep work by the prior attorney. And that's why, unfortunately, and I don't want it to be held against them, it's taking us so long to put everything together and figure out the missing pieces.
Oh, no, name the parties who you're saying didn't complete adequate discovery.
Name the parties that
Oh, yeah, who are you talking about?
The state.
Okay.
So the issue, Judge, is that I don't think that this should be held against him. He's facing substantial jail time. It's an enhanced first degree possession with intent to deliver. And so those cases, they require a lot of links, a lot of connecting the dots. And so my argument for the continuance would be that we definitely need some more time. Just
all right, the video is like an hour. What did you say, an hour and what? So
the 12 videos, each one starting at least at about an hour and a half long.
All right, so y'all need to watch the videos today. He's here, you're here, watch the videos. Next point.
We'll do, Your Honor. But the other point is that this is a case that has a lot to it. And so it's not just a regular, like a DWI third or another felony that you could get ready for very quickly. And so given the nature of this case and the prep work for it, that is a little bit above and beyond another felony in this court. That's also the reason for the continuance.
All right, but you all knew that this was set for jury trial. And so you all chose to do it. You've been given your 10 days. So what's your other grounds for a motion for continuance?
That I don't have any other grounds for my motion, Your Honor.
All right, so you all need to look at whatever video she says he needs to see. If you will load it up so she can watch the video with her client.
And Judge, I tried to do that when I was here about a week and a half ago, and the state never was able to give me the video because they were too busy, and so I.
Well, do you see anyone else here now? Load up the video so she can watch it with her client.
Don't you have access to it now?
We requested, but it doesn't come over right away.
So you
It
don't
takes-
have it?
So the other issue, Judge, is we have a motion to inspect and examine physical evidence. The state tells me that they're not opposed to it.
Well, you all should have done that before your 10 days. You had plenty of time to inspect evidence. So,
Okay, is the court going to rule on it?
oh yeah, you can expect whatever evidence you want to inspect, but I am not granting a motion for continuance because you all have not inspected evidence that was always available.
Would you like a copy?
They've given me copies of your motion. So state, she wants to inspect evidence. Is there any other motion?
Judge, it's just, there's two motions for each cause number.
Okay,
So I just wanted to see if we could get your signature on both cause numbers.
okay. And other than that, is there any other motion?
Yes, we have a motion to require disclosure of all informers relied upon and for production of said informers.
All right, so what are you basing that? And you're speaking of a confidential informant?
I believe it is, Your Honor.
All right, so there are certain grounds legally where you're allowed to that information. So what are you basing that request
So
on?
Judge, there's a reference to an anonymous tip by the detective in this report. And so I don't know, I think we need to call him in to at least get some testimony about what the anonymous tip was. And generally speaking, like, what's the nature of it? What did it reveal? And is it somebody that this person has worked with in the past? Because that's all I have is that it's an anonymous tip. There's no other
Stay.
information included there.
I can call Ramirez, see if we can get him here.
Okay.
And then we just have other pretrial motions that I
Alright,
expect
sure.
we could argue.
Did you all confer with the state on your pretrial motions?
I haven't. Does the court want to take them up at this time?
Well, I mean, don't you want to confer with the state to see if they're in agreement with your motions? If you don't want to do that, I will hear them. But it would seem it will be economical to see whether or not the state agrees with your motion, then maybe you wouldn't need to have a hearing on it.
Yes, sir.
Yeah. She says she has motions. Do you have copies of those? The other ones? I only have two. The only one I have is the inspection motions. I don't have the rest. I mean, how long has this been sitting around?
January.
Oh. Like, since January, why am I just not receiving it?
I think, try to follow up on it, so if they never received it. So. I will take it to them.
No, I'm just signing it. I don't, attorneys shouldn't have to wait months to get a voucher signed or paid. All right, while y'all are going over these motions, you need to start watching a video with him, and I'll take your motions up after you finish watching a video.
The prosecutor doesn't agree with the two motions.
All right, so go ahead and watch the video so we can get that out of the way. These motions will only take 5 minutes, maybe.
Okay,
All right, thank you.
I'm sorry, am I showing him the video on the prosecutor's laptop or?
However you all do it.
Okay, that's the only way to do it because we don't have the video.
All right, so this is the thing. If y'all want me, I will step from the bench. I will load up the video so that you can watch it. I don't see that as my job. So you all need to talk to each other. I don't know why it's so hard to talk to each other and get things done. You say you want to see a video, then you're going to watch the video, but this case is going to trial today. We're doing jury selection, and that jury selection, I'm giving y'all this morning to do your videos. That jury selection is happening this afternoon. So either y'all want to get together and look at the videos or you don't, but at 1:30, we're doing jury selection. All right. The first things is it was the court's understanding that you all were only proceeding on one case. Defense, my understanding, you've requested that the cases be consolidated. All right. And are these cases on different dates?
No, they're out of the same.
All right, so Mr. Reyes, your attorney is asking that these cases be consolidated, which means that they be tried together. Do you understand? Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, do you have any objections to these cases being tried together? All right, so then both cases will be tried together. And counsel, if you could, I will need an additional cause number, I should say, written on the election of punishment, the written sworn motion for community, request for community supervision. Yes, you submitted them separately, but when we do the jury trial, it's going to be all on one charge, and I don't want any record to be unclear if this is appealed. Yes. So if you'll just make sure you do that for the election for punishment and also for the written sworn motion for community supervision.
Yeah.
And also for the trial court certification. And if you want to, you can just, it's already been file stamped, so you'll probably have to do just another one since it's already file stamped for the record.
Okay.
All right. And Yaya, if you could do another trial court certification. And it's going to be both cause numbers. Yes. And Yaya, I don't know, do you need to do something specifically as far as judgments are concerned, if judgments need to be made since they're combining the two cases?
I'll have to ask,
All right, because I know Odyssey has changed things.
Yes.
All right. So there's something else you wanted to go up?
Yes.
Yes.
Our like there is an issue concerning several of our constitution are at issue here. We believe that first is concerning the fair trial under the 6th and 14th Amendments, as well as his due process rights under the 14th Amendment is under the due process rights is entitled to fair trial. And so we feel like since the state does extend to law enforcement officers, they have been in possession of this evidence for months. We just got access to, I believe it's a total of 6 videos as of today. 2 more were uploaded while we were reviewing evidence with Felipe today. We were only able to get through 2 of them with our client. They are extensive, and since we did review them, we were able to actually identify some material in statutory evidence. And so that is why it's important to be able to have that time to review them.
State?
I agree.
No, I'm not asking whether you agree with their argument or not. I want to know whether or not you just uploaded videos or did they have prior access to them? That's what I want to know.
No, these recordings were uploaded within the past 4 days.
All right. Next.
Could we have a rolling on our motion?
Is that all she's alleged in the motion for continuance? All right, motion for continuance is denied.
And that being said, I'd like to take up our motion for witness list that was filed on both cause numbers on May 16th, 2025. We just got the witness list on the cause numbers from the state on May 23rd, 2025, so it's not timely filing and notice of the state's witnesses. We did timely file our test estimates, got retained on this case. And so at this point, I'm asking that the court excludes any of the witnesses that are on the state's witness.
Under 39.14, time of filing is not later than 30 days prior to trial. State's defense's request was made within the past 20 days. So that would seem to not comport with 39.14's requirements for the motions from witnesses. Moreover, the witness list specifically applies to requests for expert witnesses rather than state's witnesses in general.
All right, that will be denied.
That,
Yes.
the Supreme Court did rule in US versus Akers that, the, can you just scoop, I'm sorry, here, can you put this out, please? Yeah, that one. Apologies, Judge.
No
So
problem.
I would first actually like to see that Article 39.14 does require discovery 30 days prior to the date of trial. And that evidence included within that evidence is the state's witness list. And additionally, in US versus Akers, which is what I was talking about previously, the Supreme Court did assert that it is essentially not limited to the defense's request for such evidence. It is anything that may be, the state does have a constitutional duty to provide anything that is essential. Right, so it's not strictly. And that we did file that motion for witness necessity. So it was 50 possibility for us by 30 days out, but it wasn't in a popular state. We had this case for several months now. So that's another consideration I think the court can consider when deciding whether we're going to strike the witness except for the notice.
Any response, State?
39.14 is triggered by a request served upon the state. There was no request for 39.14 material served upon the state prior to this defense firm's becoming involved in this case. So they are correct that this information was not furnished prior to their filing of that notice. Under 39.14's own provisions, it only becomes operative until defense serves a request on the state. It wasn't done until they became involved.
Judge, and just further under Martinez v. State, I think that the crux of this provision is to delay any unfair surprise to the defense, and they've had access to the discovery of the prosecution guide and the videos, and so that gives them notice of any witness that we would intend to call in trial.
All right, that's denied.
Judge, so the next motion that I wanted to address with the court was the motion to require the state here the appointment in open court. So are we going to, I guess, run that this trial?
Well, my understanding, and this was done off the record in the presence of defense counsel. I'm sorry, in the presence of defense counsel, the state informed the defense that that was an anonymous tip, and that anonymous tip was done through Crime Stoppers. Is that correct?
Yes, that is what the detective responsible for this case told me.
So is there an informant in this case? Because there's a difference between a confidential informant and an anonymous tip.
As far as I'm aware, Judge, no, there is not a confidential informant involved in this case.
So they're saying there is no confidential informant. That's what the cross-examination is for.
Yes, but if it comes out that it did involve a confidential informant, then there's no going backwards, because we may be entitled to know who that confidential informant is that we can use to prepare for trial if they were able to be or they know that information that is exculpatory or mitigating for my client. And at that point, it's going to be waived during the actual in-trial testing of that.
Well, it appears to the court as what you're seeking is to have the benefit of cross-examining every witness before a jury is seated to hear the cross-examination. The state has informed you that there is no confidential informant. So There is no hearing to be had where outside the presence of a jury, you question every witness and say, was there a confidential informant involved in this case? The state has told you there is no confidential informant. There's anonymous tip from Crime Stoppers.
Well, I think that, is that, I mean, we were also told by the state, there's also representations that there were not recordings for one of the officers. Case that the body worn camera or no dash camera, it's the state like actually required them to inquire as to that, well then dash camera and non-worn camera for the officer that state previously they didn't have, she ended up popping up, so we have to be very careful with this case. Because of all the different parties involved and just taking that information at face value, I really do think it's only one officer, but you could also take the motion to suppress with that one officer as well. And in terms of the admissibility of all of this, because the appeals court have said that the trial court is right to determine a state refusal to identify the informant, where the officers either claim that they no longer have the informant's details or agree that the informant had this.
But they're saying they don't have an informant. So the fact, what you're presenting to the court stating that there are specific reasons for the court to grant the release of an informant's identification, they're saying an informant does not exist.
That's what they're saying. That I did here to actually confirm.
All right. So is there anything else?
No, they said the remedies would be a dismissal, and so I think that has to address those remedies or jury selection.
All right. Are the jurors outside? All right. Each side will have 30 minutes.